26. Writing a dissertation. Dear Alex, Nick has asked me if I could give you some tips on writing a dissertation. I'm more than happy to help out. Many of the tips that Nick has given you in his letter on writing an essay, for example, in respect of writing style, will come in handy when you come to writing a dissertation. However, dissertations differ in a number of respects from essays. For example, they are markedly longer, generally between 8,000 and 15,000 words. You will have a longer period of time to write the dissertation, perhaps the whole academic year. The dissertation will probably not be designed to assess what you have learned over a course, but is rather a self-directed project. You will be required to conduct your own research in order to write a dissertation, and you may be asked to decide upon your own dissertation topic. In general, you will likely have greater freedom to shape your approach to the topic and your line of argument than in a course or exam essay. There is also a greater expectation that your piece of writing will put forward original ideas and arguments and entail original research. What follows are a number of key points that you need to bear in mind if you ever have the pleasure of writing a dissertation. Picking a topic. The first task is to decide upon a topic. This decision is of the utmost importance because it will shape the destiny of your entire project. Now you may have a topic set for you. In this case, you will probably still find the points in this section helpful, not least because set topics can deliberately be framed in broad terms to allow students the freedom to take their own distinctive angle on the dissertation topic. For example, a topic such as the following allows for a range of different angles to be taken. Parliament ought to be sovereign. Discuss. The process of deciding the angle you take, or the focus of your dissertation, will likely be similar to the process someone goes through in selecting and refining a topic for themselves. Interests. Yours and others. The topic should be one that interests you. If a topic bores you, you may find it difficult to motivate yourself to spend long hours researching it and thinking about it. In contrast, if you are interested in a topic, you are more likely to find the process stimulating and will get more out of it and probably produce a better dissertation. 2 further points. First, note that an interest in a subject is not the same as feeling passionate about a subject. There is no rule against researching something that you have strong feelings about. However, there is a greater risk that you may not bring an objective mind and scholarly approach to your research. It is generally the case that people write their best work about topics they find intellectually stimulating and interesting, but which they come to with no strong views one way or the other. Second, if you are set a topic that does not initially appeal to you, give it a chance. Most topics become far more interesting once you get stuck in, and you may find your own angle on the topic which you find stimulating. If the topic still does not appeal to you, then simply treat the dissertation as a means to an end, get on with the job, and do the best that you can. At the very least, it will be a character-building exercise, and you will learn a great deal from the process, whether you are enthused by the topic or not. In selecting your topic, it may be worth thinking about whether there will be a wider interest in your topic. A good piece of work is a good piece of work regardless of whether there is a wider audience for it. However, consideration of whether there is likely to be a wider audience for your work is relevant if you would like to eventually submit your dissertation or a revised version of it for publication, say, in a student law review. Thus, you may want to consider whether and how your proposed topic links in with contemporary academic debates, whether it addresses a significant issue which is likely to come before the higher courts, or whether it relates to ongoing debates about possible legislative reform. However, don't spend too much time speculating about whether a topic is likely to be of wider interest. If a dissertation presents an original, thought-provoking, and well-researched argument, it ought to be of interest to others who are academically minded, regardless of the specific subject matter it addresses. While the most important thing is what you learn through the dissertation process. Originality. A critical consideration in deciding upon your topic is the degree to which any given topic affords the opportunity for original thinking and research. This is important because, all things being equal, you will receive a higher grade if your dissertation evinces original thought. The grading system rightly places a premium not only on your ability to understand legal materials, but also your ability to formulate and develop new ideas and arguments. More generally, research which advances legal knowledge is clearly far more valuable than research that does not. Having stressed the importance of originality, it is important to emphasize that you ought to have realistic expectations of yourself. No one expects an undergraduate dissertation to present some novel theory that will unify the whole of the law of obligations or settle disputes about the basis of law. You can produce good, original, and thought-provoking research without revolutionizing legal thought. Indeed, there are dangers in seeking to be too profound, in that you may end up overreaching and confusing yourself and your audience. There are various sources of originality. You may choose to analyze a novel legal development which has not yet been the subject of serious analysis, such as an emergent line of cases or a new statute. You can adopt a new approach to analyzing an established area of law, such as an historical analysis of how the body of law has developed over time, or a comparative approach which considers how different legal systems approach the same legal issue. You may contribute an innovative line of argument to a pre-existing legal debate, or provide an original critique of an established line of academic thinking about a particular subject. Viability. However interesting and original a topic, it must also be viable. The viability of a topic is determined by whether it is possible to write a good dissertation on that topic given certain parameters, the most important being time frame and word limit. To illustrate this point, let us consider the following possible topics. 1. A critical evaluation of the law of damages across the law of torts. 2. A critical evaluation of the law of damages in the tort of false imprisonment. 3. A critical evaluation of the damages principle in R. Lumba v. Secretary of State for the Home Department, a case in the field of false imprisonment, which holds that where the claimant suffers an unlawful imprisonment on the facts, and therefore establishes liability for false imprisonment, they may nevertheless be denied substantial damages if the defendant, often a public officer or public authority in theory, had the power to detain them lawfully. Assuming a word limit of 8,000 words, Topic 1 ought to be rejected as simply not viable. Any attempted analysis of the law of damages across the whole of tort law, including negligence, nuisance, defamation, the trespassary torts, the economic torts, and statutory torts, could only be done very superficially, and therefore very badly, within 8,000 words. Further, it would take far longer than one academic year to conduct the research required for this topic, bearing in mind the time you need to dedicate to other courses and extracurricular commitments. Therefore, the choice is between 2 and 3. In making this choice, we face an inevitable trade-off between breadth and depth. This trade-off ought in general to be resolved in favor of depth, and thus in favor of Topic 3. You will usually find that what, on the surface, may appear to be the narrowest of topics will end up raising a plethora of complex and interesting issues, and that the broader your topic, the more difficult it will be to engage in the topic as thoroughly as you might a narrower topic. Let us take Topic 2 as an example. The law of damages within false imprisonment is a large body of law. It includes rules and principles relating to compensatory damages, exemplary damages, and nominal damages, including those rules and principles which govern when each type of damages ought to be awarded and the assessment of quantum. That this is a large body of law will cause significant problems within an 8,000-word dissertation. On the one hand, there is a risk that you will spend a significant portion of the dissertation describing what the law of damages is, leaving yourself too few words to conduct a thorough critical examination of the state of the law. In this way, you will have deprived yourself of the opportunity to demonstrate to the examiner your capacity for original criticism. On the other hand, in seeking to leave yourself enough words in which to do a thorough job of critically evaluating the relevant rules and principles, there is a risk of presenting an overly simplistic description of those rules and principles, for example by passing over the reality that the law is not clear in certain respects. Not only is superficial description of the law a cause for concern in itself, but analysis based on an account of the law, which passes over its nuances and complexities, is unlikely to be convincing. Reading and talking. In order to identify a potential topic or range of potential topics and test them against the above guidance, you must know something of the substance of the topics under consideration. It is therefore important that you do some general reading around the topics before settling upon one. You might want to read relevant parts of a leading textbook, the leading case in the field, or a significant recent case, and/or 2 or 3 leading articles. This will help you to determine whether you are interested in the topic, and will also help you to start thinking about the line of argument you might take in the dissertation. Importantly, the more you know about a field, the more you will be able to refine and narrow your topic. So you may start with a general interest in the law of damages in tort, then, after reading a number of articles or cases, find that you are particularly interested in the law of damages and false imprisonment. From a little further research, you may discover that the case of lumber raises very interesting and significant issues, and has not yet been the subject of serious analysis in the literature, leaving the door open for an original contribution. You will also find it helpful to talk to people about your topic, in particular your dissertation supervisor, who will be able to offer you some inside knowledge of the field. They may be able to advise you how much has been written on your proposed topic, suggest how you might narrow your topic, and/or suggest some initial readings. Although your supervisor is your first port of call, you may also want to test out your proposed topic and line of argument on a range of people with some knowledge of the relevant legal field, including fellow students. This advice about talking to people is equally relevant to the process of researching and writing the dissertation. Some of the most significant insights I have had in relation to my research have come during a stop and chat, to quote Larry David in The Corridor, or over a coffee with a friend. At the end of this process of talking, reading, and reflecting, you should have a clear research question, to which your dissertation will seek to provide an answer. Illustrative examples are: 1. Should the law of negligence recognize that public authorities owe duties to take reasonable steps to protect an individual, where the relevant authority knows of a real and immediate threat to that individual's life from the acts of a third party? 2. Should exemplary damages be available for a breach of contract? And 3. Should the law require a newspaper to give prior notice and an opportunity to comment to an individual before the paper publishes a story about that individual? Finding an approach to the topic. Intimately connected to the task of deciding your topic, and of ongoing relevance as you research and write the dissertation, is your approach to your topic. In more technical terms, your methodology. An awareness of different approaches is important for several reasons. First, your approach will often provide the original element of a dissertation. Second, you need to have a clear idea of the approach or approaches you are taking in order to articulate clearly your central lines of argument. Third, although the matter cannot be discussed in detail here, different approaches entail different techniques and different potential pitfalls, and it is important that you are aware of the salient features of any particular approach, so that you implement the approach rigorously and avoid any pitfalls. Before going on, I should note that, while it is important that you are aware of your approach, it is equally important that you do not become fixated upon it. Otherwise, you may never get on with the tasks of researching and writing the dissertation. This letter is not the place for a detailed exposition of the different approaches that may be taken to legal research. However, it is worth briefly outlining a few different approaches in order to illustrate the variety of approaches open to you. I focus particularly on doctrinal and theoretical approaches, as these are the most common approaches to legal research. Doctrinal approaches. The most prevalent form of legal research is doctrinal. This approach involves the examination of legal doctrine, doctrine being the body of rules and principles based in legal sources, such as legislation and judicial decisions. Usually, a doctrinal researcher is concerned with one body of doctrine, such as the law of contract or administrative law, and typically a particular sub-body of doctrine within these general fields, such as the law of expectation damages or of legitimate expectations. The first task of a doctrinal scholar is to state what the law is. This may seem an easy task on the face of it, but it will require the researcher to locate all of the relevant case law, read those cases, and distill the rules and principles enunciated therein, and sort that collection of rules and principles into a coherent and intelligible order, so far as one exists. In undertaking this task, you must be open to the possibility that the law, shaped as it has been by many hands over many years, may in certain respects lack coherence or consistency. If this is the case, you ought to say so. A common challenge in doctrinal research is that it can often be the case that the law is not clear in some respect, for example, because of apparently conflicting precedents, or because an issue has not been squarely addressed by the courts, leaving scope for argument and original analysis as to what the best account of the legal position is. There may also be different ways of sorting and categorizing the law, and scope for original argument as to which way is best, while we may wish to categorize the law differently for different purposes. For example, you might provide a statement of the law according to the nature of legal obligations, for example separating tort from contract on the basis that contract is based on consent, whereas tort is an obligation imposed by the law. Another person might structure their statement of the law in a different way, for example according to the subject matter that the law addresses, such as the law as it relates to ships or to the media. The second task of the doctrinal scholar is one of critical analysis, and in particular critical analysis by reference to established legal values, such as coherence, consistency, rationality, and justification. For example, you might criticize a Supreme Court judgment in the field of false imprisonment because it is inconsistent with an important line of House of Lords precedent, which was not considered or which you believe was misinterpreted by the Supreme Court. You might criticize the judgment on the basis that it creates an incoherence in the law by establishing a new rule that cannot be reconciled with other long-standing rules within false imprisonment. Or you might criticize the decision on the basis that the reasoning adopted by the court is unconvincing, for example, because it is based on arguments that on closer analysis conflict with one another, or premised upon assumptions which can be shown to be false. Theoretical approaches. Another common approach to legal research is theoretical. Theory is a difficult idea to pin down, but one useful way of thinking about it is in terms of levels of abstraction. When we are engaged in theoretical research, we are seeking to explain or evaluate the law from a bird's eye view, and therefore will be less engaged with the messy detail of particular legal rules and principles. The bird may be flying higher above the doctrinal landscape, such that our analysis is far removed from doctrine, and we are considering the law in much more abstract or philosophical terms. For example, we might ask what the possible rationales are for having a law of vicarious liability in tort, or why damages should ever be an appropriate legal remedy. The bird may be flying lower, in which case our theory will engage more closely with doctrine. For example, a dissertation may argue that we can explain the significant doctrinal features of the tort of false imprisonment by reference to the distinctive underlying function of the tort, which is to afford strong legal protection to the fundamental right to liberty. Note that although the dissertation will be more engaged with doctrine, it is concerned with significant features of doctrine, such as whether liability is in general strict or fault-based, or whether the tort is actionable without proof of loss, rather than the outcomes of particular cases or the intricate details of particular rules. Other approaches. There are many other possible approaches. You might undertake comparative research. For example, you might consider how different legal systems approach analogous legal issues, assessing the degree of divergence or convergence among the relevant legal systems, and seeking to understand why, for instance, different approaches may have emerged, given distinctive contextual features within each jurisdiction. You may take an interdisciplinary approach, using insights from other disciplines to help analyze legal issues. Thus, we might consider research into behavioral psychology in assessing the claim that the prospect of damages liability for defective products may incentivize product manufacturers to take more care in the production of their goods. You might take an historical approach, considering how changing social, economic and/or political conditions have shaped the development of a particular body of legal doctrine over a particular period of time. Or you might prefer a contextual approach, considering how legal rules operate in context. For example, a researcher may want to examine whether and how public officials take into account human rights law in exercising their powers, discretions, and duties. This sort of research will usually require empirical research, such as conducting interviews with officials or spending time at a public authority observing bureaucratic behavior. Combining approaches. In a great many dissertations, a number of approaches will be utilized. For example, we will need to know what the law is, using orthodox doctrinal techniques, before we are able to develop a theory to explain the law. In conducting a critical analysis of a new rule enunciated in a recent Supreme Court decision, we may wish to look at the approach taken to the same legal issue in other comparable common law jurisdictions, such as Australia or New Zealand. The courts in these jurisdictions may have adopted a different rule, and you might find that the court's reasoning helps to demonstrate the weaknesses of the UK Supreme Court's approach. You may wish to critically examine a court's reliance on the argument that the imposition of a duty of care on a police authority will help to incentivize good practice within the police forces. On the one hand, you may criticize the court's reasoning on the basis of established legal values, for example on the basis that the use of policy arguments may undermine the coherence of the law of negligence. On the other hand, you may also wish to criticize it on the basis of empirical studies, which demonstrate that the effects of imposing liability on police forces are not at all clear, suggesting that the court's assumption that imposition of a duty will have positive behavioral effects may be misplaced. Thus, different approaches can be combined to powerful effect. However, it is important to remember that in order to avoid confused analysis, you need to have a clear idea of when you are utilizing one approach or the other. Positive and normative analysis. Lastly, I ought to draw your attention to one significant distinction, which cuts across all of the aforementioned approaches, and with which all legal researchers ought to be familiar. That is the distinction between positive and normative analysis. Put simply, positive analysis is an analysis of what the law is. Examples of positive analysis include 1. The doctrinal task of describing what the law of false imprisonment is, and 2. The development of a theory which seeks to explain the law of false imprisonment at a certain level of abstraction. Normative analysis is an analysis of what the law ought to be. In other words, it is a prescriptive form of analysis, seeking to argue for what the law should be ideally. Examples of normative analysis include 1. The argument that the damages principle in lumba ought to be rejected because it affords insufficient protection to liberty, and 2. The argument that courts ought not to be given the power to strike down legislation passed by Parliament because this would be inconsistent with democratic principles. Importantly, an ought cannot be derived from an is. Thus, it does not follow from the fact that the damages principle in lumba is the law of England at the moment that it represents a sound or justifiable principle, such that it ought to be the law of England. Equally, when you are conducting positive analysis, such as articulating a theoretical explanation of the law, you must be careful not to allow your explanation to be captured by your normative views of what the law ought to be, as this would be to confuse two different tasks: explanation and prescription. This is not to say that positive and normative analysis cannot feature in the same dissertation. They almost always will. For example, you might engage in a doctrinal analysis of a body of case law and find that conflicting rules emerge from two lines of authority, and then go on to articulate a normative argument as to which rule you think ought to be preferred. The important point is to keep clear in your mind and in your dissertation when you are engaged in positive analysis and when you are engaged in normative analysis, researching the dissertation. So let's assume you now have your topic and an idea of the general approach you want to take to it. The time has come to begin the process of researching and writing the dissertation. I will discuss researching and writing the dissertation separately, research in this part, and writing in the next, as some structure has to be imposed on the discussion. However, it is worth recording that it is somewhat artificial to address the two separately. The two processes are inherently intertwined, as I say below. The writing process is a core aspect of the research process, and while you must begin the research process before you start writing, putting pen to paper by no means marks the end of the research process. Sourcing material. One thing leads to another. When faced with the task of researching a new topic, it can be difficult to know where to begin. It is easy to respond by procrastinating. This ought to be avoided. In my experience, the best way to get into a topic, particularly if you are unfamiliar with it, is to begin with reference works. These include textbooks, legal encyclopedias such as Halsbury's Laws of England, or research handbooks, such as the Oxford Handbook of Empirical Legal Research or the Oxford Handbook of Comparative Law. Thus, your first step might be to go to the library and round up a number of the leading textbooks and reference works in your field. Just as valuable as the material in the text of these reference works, if not more valuable for your purposes, are the references in the footnotes. Within the footnotes, you might find references to books which specifically address your topic, which you can then look up and read. From reading the relevant chapters in a number of reference works, you will start to see which journal articles are frequently cited and relied on by the authors. Some textbooks even have a list of further reading at the end of each chapter, which can be a useful resource for locating relevant articles and books. You can seek out articles, either by looking up the paper copies of the journals in the library or searching online resources such as Westlaw or Heinenlein. From reading the reference works and scouring the footnotes, you will similarly get a clear idea of the leading cases in your field of research, which you can then look up in the law reports or in legal databases such as Westlaw or LexisNexis. One thing will lead to another. From each book, article, or case you look up in the course of your initial research sweep, you will learn more about your topic and find references to further relevant material. You will also start to get a feel for resources, which are likely to be a source of further relevant material. For example, if you are researching a topic in constitutional or administrative law, you will no doubt begin to see that many of the articles written on your topic appear in specialist public law journals, such as Public Law and Judicial Review, while some appear in generalist journals, such as the Modern Law Review or the Cambridge Law Journal. You can then use Westlaw or LexisNexis to conduct keyword searches of past volumes of these journals, or you can go to the library shelves and flick through the contents pages of past volumes to see if you can spot anything of interest. As your research goes on, you will find that you move from general reading around a subject to distinct streams of research, each of these streams correlating with subtopics in your dissertation. For example, part of your dissertation may address how the area of law you are looking at has developed over time, which will require you to locate and read the most important cases decided in the field. Another aspect of your dissertation may be a critical comparative analysis of the area of law you are concerned with, meaning that you will need to read relevant cases from other jurisdictions. Yet another aspect of your dissertation may be a consideration of different theoretical explanations of that area of law, such that you need to locate and read articles and books written by leading theorists in the field. It is important to emphasize that there will often be material that is relevant to your topic, which is not contained in textbooks or in articles written within your field of research. Indeed, an important source of originality in a dissertation will be the inclusion of original research. For example, there may be cases which bear on your topic which have not been analyzed in the existing academic commentary, and which have been missed in later court decisions, or there may be literature in other fields, such as political science, which might help you to analyze your topic in an original way. The key to conducting this sort of original research is to figure out where to look. If you are seeking out relevant political science literature, you can start with reference works in political science, such as the Oxford Handbook of Political Science, and move on from there. If you are searching for cases, you will probably need to run keyword searches on electronic legal databases and carefully analyze the results for relevant material. There are other facilities on electronic databases which can be helpful. For instance, if you uncover a relevant case on Westlaw, it is possible to bring up a screen which lists later cases which have applied or distinguished that case. There may be specialist law reports which report cases in your field of interest, have reasonably detailed tables of contents, subject indexes, and helpful headnotes, and which you can spend an afternoon flicking through at the library. For example, if you are researching an area in constitutional or administrative law, the Administrative Court Digest, which provides summaries of public law cases, would be useful. While if you are researching European human rights law, the European Human Rights Reports would be an important resource. While the most common sources in conducting legal research will be primary materials such as cases and legislation, and secondary materials such as textbooks and journal articles, you should bear in mind that the sources that you ought to consult will vary with your approach and the subject matter of your dissertation. For example, if you are conducting historical research, you may have to visit archives, such as the National Archives, to go through historical papers, such as letters or newspapers, read autobiographies or biographies of important figures from the period you are researching, and/or read cases and academic commentary from the relevant time period. If you are conducting research into the meaning of provisions of a statute, you may have to consider background material, such as policy documents prepared by the government department, which was responsible for proposing the legislation, the record of the parliamentary debates on the bill known as Hansard, and the reports of parliamentary committees which scrutinized and heard evidence on the bill. Some legislation implements reports produced by bodies, such as the Law Commission or ad hoc special inquiries set up by the government. Helpfully, much of this material is published online on governmental or parliamentary websites. An important and challenging aspect of the research process can be keeping up with current developments. You cannot rely on textbooks or articles to provide an up-to-date statement of the law or repository of academic commentary. As soon as a textbook or article is published, it is almost invariably out of date. New judgments are constantly being issued, new statutory measures enacted, new government reports produced, and new academic commentary published. It is critical that you do not miss out on an important development such that your dissertation appears incomplete. While a new case or article might greatly aid your argument, there are various ways to try to keep up to date. As regards articles, you can periodically check the latest issues of the leading journals in your field, while there are various updating services which you can sign up to, and through which you will be sent an email when a new issue of a selected journal is published. In terms of textbooks, it is now very common for textbook writers to publish online updates or small hard copy supplements which detail the most recent developments in the field. It is worth noting that new editions of a textbook may come out while you are writing your dissertation, and it is important to refer to the most recent edition. In terms of cases, a very helpful resource is the Weekly Law Reports, which reports the most recent and important judgments and is published on a weekly basis, such that there is only a short lead time between the issuance of a judgment and its appearance in the reports. Similarly helpful are the recent decisions lists on the Bailey website and the Decided Cases section of the UK Supreme Court website. You can find the relevant links by going to the Useful Links section on Nick's website www.mcbridesguides.com. Various update services are available, for example through electronic databases such as Westlaw, which usually give you the option of subscribing to content based on your interests. Although many posts on legal blogs resemble soundbite journalism rather than academic scholarship, they can be useful in drawing your attention to recent developments in your field again. Nick's website will give you some relevant links. You can also sign up to relevant Twitter feeds, such as that of the UK Supreme Court at Supreme Court. From this discussion, it ought to be apparent that to conduct effective legal research, you will need to know how to use a law library and how to use electronic databases. It is important that you seek out and get the training that you need. A linked point is that librarians and help desks are there to help you, and, although they cannot do the research for you regrettably, you should not hesitate to ask for help If you are having difficulty locating books on 15th century tort law or struggling to find an obscure case on Westlaw, focus, reflection, and when to stop reading. So far, we have discussed how you might go about locating relevant sources. What follows are a few tips you should bear in mind when it comes to reading the material you have located. First, it is important to read key materials, such as leading cases in your field of research for yourself, and not rely on secondary accounts in articles or in textbooks. Each person understands material slightly differently, and each person reads material for a different purpose. A textbook writer is concerned to state the most important rules and principles within a particular field of law. This is different from your task, which is to answer a specific research question. There may be material in a particular case that is relevant to your topic, which is not flagged up in textbook discussions of the case. The textbook writer may not have considered the material relevant to his or her task, or possibly overlooked the material. Furthermore, you can only truly understand a body of law if you have spent time reading the relevant cases for yourself and taken time to form your own understanding of the rules and principles they entail. This sort of deep understanding will ultimately shine through in your dissertation and can only increase your grade. Second, it is imperative that you read with focus. In other words, when you are reading an article or case, you should constantly be thinking about how the material you are reading is relevant to your overarching research question. Linked to this point is that you should try to make notes of points in the article or case that are relevant to your topic. It is all too easy to spend days and days reading material, find a number of really important points in the material, and then not remember where you saw those points or simply forget the points because of all of the information you have taken in. When you are reading, you will often find that you have your own important observations on the material, which you will ultimately wish to include in your dissertation. It is critical that you note these points down. In this respect, it is a good idea to have a dedicated Word document in which you record any important ideas you have while reading. Third, take time to reflect. Each time you read a case or article, you need to afford yourself sufficient space and time to properly digest and think about what you have read, particularly if the case or article is of particular significance to your project. You need to think about the relevance of the material to your topic, the implications it has for your argument, and, if it is salient, how you might integrate it into your dissertation. During periods of reflection, you may feel like you are not achieving a great deal because you are not physically doing anything and you are not producing tangible outcomes. However, these periods of reflection are fundamental aspects of the research process. No one has ever produced a great piece of scholarship without engaging seriously with their source materials and thinking deeply about their subject. Indeed, deep reflection is a fundamental characteristic of academic scholarship, which marks it out from other types of writing. Fourth, you need to know when to stop reading. It is difficult to give concrete advice on this issue, because the decision to stop reading will require the exercise of your own judgment. However, a few points may help you to make the call. In making your judgment, it is important to bear in mind the reality that there will always be more to read, and you could, in truth, go on reading for years. It is also important to bear in mind that you need to afford yourself enough time to reflect on all of the material you have read, how it all fits together and relates to your argument, and to write the dissertation. A reasonable litmus test for when you ought to stop reading might be when the readings start to get repetitive, because you are coming across the same sorts of arguments and observations being made over and over again by different authors. Put another way, you ought to stop reading when you become acutely conscious of diminishing returns, i.e., the marginal benefit you derive from each extra piece of reading is getting less and less. Writing the dissertation. So you have a topic, you have an approach, and you have made progress with your research. All that is left to do is write the dissertation. In this part, I will provide some tips on structuring the dissertation and important aspects of the writing process. Nick's letter on essay writing addresses a number of topics that are also relevant to writing a dissertation, including the importance of writing clearly, paying attention to details, and not avoiding a fight, i.e., ensuring your argument is balanced. In the interests of avoiding repetition, I will not be addressing those points again here, and I would recommend that you read Nick's letter together with what follows. Structuring the dissertation. Superficially, the structure of a dissertation appears to be a formal aspect of writing. It is about the form that the argument takes rather than the substance of the argument. Nonetheless, there is a strong interrelationship between the structure of your argument and its power to convince. Rational arguments that are likely to convince a reader generally follow a rational structure, and confused arguments which are likely to baffle a reader generally follow a confused structure. As you go through the initial research process, and you reflect upon what you have read, you will find that you have a collection of arguments that you wish to make. Your task is to forge these arguments into a coherent and rational structure. One way of forging this structure is to think about the sub-questions or subtopics you need to address in order to answer your overarching question. Let's say your overarching research question is a normative inquiry into why Parliament ought to be the ultimate arbiter of human rights issues, rather than the courts. At first blush, you might say that to convincingly establish this argument you need to demonstrate that 1. There are good arguments against the judiciary having the power to finally determine human rights issues. 2. That arguments in favor of the judiciary having this power are not convincing. 3. There are good arguments for why Parliament ought to be given this power. And 4. Arguments against Parliament having this power are not convincing. Now it may be that these broad divisions provide a natural way of sorting your collection of arguments into the sections. You might then possibly go on to identify subtopics within each subtopic and further divvy up your arguments. On the other hand, the way you first identify your sub-questions or subtopics may not provide a natural template for your structure. Going back to our example, if you find that all of your arguments or a significant proportion of them cut across subtopics 1-4, it may lead to a great deal of repetition if you address the same arguments in different sections, and it may be difficult to decide where particular arguments ought to be housed. It may also be artificial to split your discussion of important lines of argument across different sections. For instance, if you find that many of your arguments in favor of parliamentary supremacy also serve as strong arguments against judicial supremacy, it might be artificial to deal with these arguments in different sections. You may thus find that another way of stating your subtopics or sub-questions may provide a more natural template for your structure. For example, instead of defining your subtopics according to type of argument, e.g., arguments for parliamentary supremacy or against judicial supremacy, you might define them according to subject matter. Thus, you might say that to make out your overarching argument, you need to consider the relative democratic legitimacy of Parliament and the courts. B. Consider the relative institutional competence of Parliament and the courts. And C. Compare and contrast the practical consequences, negative and positive, of each different model. You might find that categorizing your arguments into a structure which mirrors these subtopics helps to resolve the problems of repetition and artificiality. Sorting your arguments in this way does not mean that the task of making out propositions 1-4 is no longer relevant, only that you will seek to establish these propositions in the course of considering each subject matter. The structure changes over time. The way you think you might structure your argument after your initial research sweep may be quite different from your final structure, and you need to be flexible enough to allow your structure to evolve for the better. Returning to our parliamentary supremacy example, you may at first contemplate a structure modeled on subtopics 1-4. However, as you continue your research, you may find that groups of arguments related by subject matter, such as democratic legitimacy or practical consequences, clearly start to emerge, such that subject matter becomes a viable basis for your structure, and boasts the benefit of solving the problems you might have been having with the structure based on 1-4. The use of headings and subheadings is critical in structuring a piece of writing that is between 8,000 and 15,000 words. Indeed, a good litmus test for whether your dissertation follows a rational structure will be whether an observer familiar with your field of research can garner a rough idea of your overarching argument from a list of your headings. A common question asked by students is how many headings you ought to have, and how many levels of headings are permissible. You will have to rely upon your own common sense. For example, it seems fairly obvious that you will be more likely to use 3 levels of headings, i.e., major headings, subheadings, and sub-subheadings in a 15,000-word dissertation than in an 8,000-word piece of writing. In terms of the frequency of headings, a general piece of guidance is that you should avoid having so many headings that it disrupts the flow of your argument, while you should only generally be using headings, or at least major headings or subheadings, to demarcate divisions between groups of arguments, grouped according to some feature such as subject matter, rather than to separate single arguments, aspects of the writing process. So you have a preliminary structure for your dissertation. But when should you start filling in the detail? As early in the process as is possible. There is a common tendency amongst students to postpone the beginning of the writing process until they feel they have read everything relevant to their topic. One can understand the tendency, but it ought to be consciously resisted. One of the most important reasons for beginning the writing process as early as possible is that it is an integral part of the research process. In your mind, your arguments may be crystal clear and utterly convincing. However, it is inevitable that, when you try to commit them to paper and reason them out fully, you will begin to see gaps that need to be filled, issues that are more complex than you originally thought, and weaknesses in your argument that need to be addressed. It is typically the case that each of these issues will require you to get back to the grindstone and conduct further, more detailed, and more focused research, possibly in fields you may not have otherwise thought you needed to research. If you delay the beginning of the writing process for too long, you risk not allowing yourself sufficient time to conduct the further research required to get your argument up to scratch. Another closely linked reason not to delay writing is that you need to afford yourself adequate time to reflect on what you have written, if you are to produce top-quality scholarship. Draft sections which at first appear difficult to fault may, upon further reflection or upon completion of further research, require refinement or a complete rewrite. Indeed, it is hardly ever the case that the first draft of any part of the dissertation will end up, in its original form, in the final version. It may take reasonably long periods of reflection, time away from the dissertation, and discussions with others about your research for you to recognize weaknesses in your argument. Which aspects of your argument are redundant or add little? Ways in which your argument may be further strengthened, or how your argument might be presented more tightly and succinctly. In this way, the writing process is an iterative process, and each successive draft should entail a further refinement of your argument. You may feel that discarded arguments and drafts, which end up needing a complete rewrite, denote wasted time and effort. This is not the case. Those discarded arguments and abandoned drafts are part and parcel of writing scholarly work. If we all managed the perfect argument the first time round, writing a dissertation would not be much of a challenge, and there would be a lot more good scholarship out there than there is. Strive to write with focus. Always bear in mind the task at hand, that you are seeking to convincingly answer your research question. Every word, sentence, and paragraph that you write ought to be geared to that task. Common temptations which can work against focused writing include the temptation to include material because you personally have found the material interesting or stimulating, or the temptation to demonstrate the breadth of the research you have done, or that you understand a difficult idea. You ought to resist these temptations because succumbing to them will not help to make your dissertation more convincing. Indeed, the inclusion of material that is not relevant will probably annoy the reader, disrupt the flow and momentum of your argument, and most significantly, entail the squandering of words that could have been used for original analysis and argument, and that would have helped you to more convincingly address your research question. Someone once usefully described this insight to me as separating your story from the dissertation story. You will learn a great deal over the course of the research process. but you should only include material that advances your argument. A dissertation is not a whodunit novel. You should not keep your reader in suspense as to the conclusions you are arguing towards or why you are advancing particular arguments, holding this information back for a thrilling finale in the last few pages. You should always signal to the reader why you are making a particular set of arguments, the conclusion you are arguing towards, and how this set of arguments advances the dissertation's central argument. This helps the reader to follow your line of argument. No reader enjoys wading through a great deal of written material with no idea as to why they are being asked to read it or where the analysis is going. This advice applies to the dissertation as a whole and also to sections of the dissertation. Thus, in the introduction to the dissertation, you should clearly state the overarching argument you are advancing and the conclusion you are arguing towards. In a dissertation considering whether Parliament or the judiciary should be supreme over human rights issues, you should state clearly in the introduction whether you will be arguing that Parliament or the judiciary ought to be supreme. Equally, in each major section of the dissertation, you should include a relatively brief introduction stating what you will be arguing in that section and why. Make your argument. It is not uncommon for students to get bogged down setting out the views of other commentators on a particular topic, with the consequence that their own voice is lost, and the dissertation resembles a review of relevant commentary rather than a clear and coherent argument. As a general proposition, the views of other commentators ought not to be the centerpiece of your dissertation. Rather, your argument should be the centerpiece, and you ought to discuss or criticize the views of other academic commentators in the course of advancing your own argument. Define key concepts. If a particular concept, which is open to various interpretations, such as democracy or rights, is fundamental to your overarching argument, for example, if you are advancing a rights-based conception of the democratic state, you ought to stipulate definitions of these concepts. Otherwise, the examiner might infer that you have not done the relevant research and thinking required to properly define these terms. Further, your argument will inevitably be weakened to the extent that reliance on undefined terms plunges it into ambiguity. Footnoting is a key feature of dissertation writing that distinguishes it from a short course or exam essay. When should you footnote? In general, footnotes should be used only to make necessary citations, rather than to provide additional text. If a footnote includes text that is more than a couple of lines long, you will need to consider whether the inclusion of that text is necessary for your argument. If it is, it should go in the main text. Otherwise, it should probably be cut out. An exception applies where 1. The text is important to your argument, but 2. Including it in the main text would seriously disrupt the flow of your argument. Examples of when it is necessary to footnote include the citation of authority in support of a legal proposition in the main text, and citation of an article or book from which you have sourced an idea or concept referred to in the main text. It may also be permissible to use footnotes for illustrative purposes. For example, in the main text you might state, "Many have argued against the availability of exemplary damages for breach of contract." In the footnote, you could list a number of the articles or books that propound this argument. Students often ask what style they should follow in referencing cases or articles. Some law schools have their own style guide, which you will be required to follow. Others do not. In the latter case, the key is to ensure your referencing style is consistent, and that you include sufficient information to enable readers to easily locate the material you are citing. It will probably be a good idea to have a look at and possibly follow the citation style adopted in one of the leading journals, such as the Cambridge Law Journal or Law Quarterly Review. A last point on referencing is that, if you are citing a case or an article for a specific point, which you often will be, you ought to provide a pinpoint citation, such as a reference to the paragraph number of the case in which the point is made or the relevant page number of the article. This will make it easier for the reader to locate the relevant passage you are referring to and reassure the examiner that you have in fact read the material you are citing. A final piece of advice before you get started. The dissertation is first and foremost a learning process. No one is born an expert researcher or with a gift of polished prose. Skills of research, writing, and argumentation can only improve with experience. The dissertation provides you with an opportunity to gain such experience. Make the most of it. All the best. Jason Varroas.